Hello, everybody. I can't see you, but I think you can see me. If you can, why don't you say hi in the chat box? We had some technical difficulties getting started here, but I think we got it figured out. Hello, is anybody there? Type in chat if you're there. There we go. Hi, Anna. All right. Where did our chat go? All right, well, hello and welcome to our webinar on what happens to my what happens to my assets when I'm gone. So I'm Marty Elberg. I am of counsel attorney with the Whistler Law Firm. I practice in estate planning and probate. I try to avoid probate as much as possible, which is what we're really going to talk about here today. So here we go. And I can't see the chat, so Q&A. If we're going to have some chats, go to the question and answers. There should be a Q&A portion of it there. I don't see my chat. There's my chat. There it is. I got it. I got chat back. All right. We'll get this technology one of these days. All right. And I see Gray is on there too. Gray, can you say hi? Okay, I see you.
Hi, can you guys hear me?
All right. Yep, I can hear you.
Perfect. Sorry about that. I had technical difficulties, as Marty was saying. Thank you all for joining us today in the webinar. I'm very pleased to introduce Marty Elberg as our estate planning attorney, and he has a lot of important information to share with you regarding your assets and how to protect your family. So Marty, take it away.
All right. Thank you so much. Here we go. And just as of course, we've got to have a disclaimer as attorneys here. Nothing in this presentation should be interpreted as legal advice. This presentation is intended to help you understand the area of law, to help ask the right questions with the attorney of your choice. And of course, we always invite you to speak with us about becoming your attorney of choice for estate planning. And throughout the presentation, Gray will be posting in the chat a link that you can actually schedule a free consultation with me. All right, so what happens to your assets when you're gone? Well, the most honest answer that nobody likes to hear is it depends. It really depends on what you have and what you have in place. So just as a simple rule of thumb, if you don't have a will, you're most likely going to have to go through probate unless you've done some planning processes that I'll explain further on down this webinar. If you have a will, this always surprises people. That still requires probate. So if you have a will, or if you don't have a will, and you've got assets that need to be passed to your heirs or your beneficiaries, then you still need to go through probate. If you have a trust, chances are there's no probate necessary if everything was done correctly. So actually, let me go back to that just a second. Who knows what probate is? If you could say yes or no in the chat box.
I don't know what probate is.
You don't know what probate is? All right. Anybody else? Anybody else out there listening, watching, know what probate is or not? Just a yes or no. All right, well, you go through and answer those. So probate is actually a lawsuit against your estate when you die. That means that somebody that you've left behind has to go to court, has to open a court case, usually has to hire an attorney, and it can be fairly expensive. When I do probate, it depends on what type of a case it is, but it's generally around the $5,000 mark. And it can be much more. It can be a little bit less depending on what assets are in your estate. Okay. So once we get that estate open in the probate case, we have to file notice to creditors. So we have to let your creditors know that you have died. If you're over 55, we have to let Medicaid know that you've died. So Florida Medicaid. And if you have any claims, then they'll, of course, file the claims. And those are the first people that get paid. Actually, the second person that gets paid. I'm usually the first person that gets paid as the attorney for the estate, because without the attorney to open up the estate, it's not going to go through probate. So it's the court costs, then the funeral costs, then the last healthcare costs, then the creditors, then the heirs or beneficiaries get paid anything that's left. All right. So the difference between heirs and beneficiaries is one simple thing. If you've got a will, they're beneficiaries because you've named them. So think of beneficiaries as somebody that's been named. Okay. You can name your beneficiaries in a trust as well, and a couple other documents. So your 401k, your IRAs, your life insurance policies. You probably heard of beneficiaries. So heirs, and a lot of people confuse heirs with beneficiaries. They're very similar, but heirs are determined by the law of the state. Okay, so the state does have a plan for you. That's actually the next slide. So let's move right into there. All right, so the state's plan has determined who your heirs are, who your beneficiaries are, but they're your heirs because you didn't have a will naming them as beneficiaries. So if you're married, they'll be your wife. If you have kids, your kids are included. If you just have kids, then they'll be your kids. If you've got kids from a prior marriage, of course, that's going to play a part in who gets what if you're still married. So grandkids, parents, siblings, aunts and uncles, not to your friends, not to your live-in partner, not to your business partner, not to whoever you've had this verbal agreement for your entire life, unless they fall in this line of heirs. Okay, so important to know that if you just say, hey, when I die, you get everything, doesn't always work like that. One of the probates that I handled a while back was a young lady who was recently divorced from her husband, and they had an agreement that he was going to get the house, but she was still on the house. They did not have it titled as joint tenants with rights survivors, and I'll talk about that in a little bit. They didn't have, and they weren't married anymore. So that broke the unity that gave them marital rights. So they were divorced. He was supposed to get the house. They had a verbal agreement. She didn't write a will. She didn't have a trust. They didn't have anything. So mom, the mother of this child, became the personal representative, and we had to get the house basically divided. So now mom and dad, who were actually not even living together, they were divorced. So mom and dad are divorced. So they each get a quarter of the house that the daughter used to own with the husband. I know it sounds very convoluted and it's hard to follow, and that's what happens when we don't have an estate plan. I actually become a puzzle creator. I put the puzzle together. I have all the different parts and I lay them all out and I say, okay, this is what you have. This is who's alive. These are the people that are getting whatever you left behind. Okay, so don't leave it up to me. Don't leave it up to the court. It's important to have a plan in place. All right, so the state's plan, sure, it might be perfect if you've got a very simple estate and you want everything to go to your wife, but just make sure you don't have kids from a prior marriage because that causes some difficulties. All right, so for example, Mr. and Mrs. Frown have a child. Mr. Frown died and left no will. Mrs. Frown's only substantial asset, Mr. Frown's only substantial asset was his home from before the marriage, titled in his name alone. You see this a lot, by the way, in probates. And the wife is generally, usually, almost always shocked to hear that the house does not go to her. Even though they have kids, even if the kids are older, that's why I've got the picture of the old guys here. The kids will receive, I'm sorry, the wife, so this over here is Mrs. Frown. She will receive life estate in the house. Okay, that means she gets the right to live in that house until she dies. She does not have the right to sell it. She doesn't have the right to mortgage it. She doesn't have the right to do any of those things that you would think that you would be able to do since it was the home that you lived in. Now, she has an option to take that house as a tenant in common with the children. So she could own 1/2 of that house, but she has to make that option happen by going to the court and saying, hey, I want to be tenant in common instead of having my life estate. That leaves the children with a remainder interest, or if that election is taken for the half interest, they would split half of the house as tenants in common with their mother. Okay, the remainder person means that once mom dies, they now get the property. So it goes to the kids. All right, so that's not usually what Mr. Frown, it's probably not what Mr. Frown intended on, especially because his kids were older. He probably just wanted or thought that his wife was going to keep the property and be able to do whatever she wanted with it. Not the case. So it's so important, again, to have a plan and know what you have. All right, so let's go to a will-based plan. Will-based plan, remember, allows you to direct what assets you want to go to what person. So this is a step better than the state's plan, especially if you are in the situation with Mr. Frown, where you wanted your wife to have the asset. You wanted your wife to have the house, not your wife and kids. So you get to choose your spouse, your favorite kid. And yeah, I say favorite kid. I'm actually preparing an estate plan right now. I just finished it yesterday, where a mother adopted 3 children and has 2 of her own. Her intention is that everything that she has goes to the 2 older children, because the 3 younger children will be taken care of by their father, okay, by the other adopted parent. So, and there's a significant age difference as well. So it's important that we mention all of the kids so that they don't go to the courts and say, well, see, they didn't even remember that I was there. I should get something. And sometimes that works. So when we mention the children and say they will not receive anything, then the court is more inclined to follow that will and carry it out the way that you wanted it to. All right. So yeah, favorite kids. I absolutely meant to say that. Friends, live-in partner. So there are a lot of people that are just refusing to get married now. They own a house together. They may not own it in the proper title, so that when one dies, it goes to the other. So you can name that live-in partner as a beneficiary of your house. Business partner, same thing there. Let's go through a quick example here. So we've got Mr. Smith and Mrs. Jones. They are not married. Mrs. Jones died and left a will. She owned the house that she and Mr. Smith lived in. She also owned a business with her brother. See the issues that we have here, or could have here, if she didn't have a will? Well, luckily she did have a will, like we mentioned, and she dies. Not luckily that she dies, of course, but luckily that she left a will, because she left the house to Mr. Smith. She left the business to her brother, right? Makes sense. Mr. Smith was living in the house. She had a business, her business partner was her brother. So she was able to choose who got her assets. She also left behind her son. And because she had a will, she could name, she could name Mr. Smith as the little boy's guardian. Okay, so that's another important aspect of having a will. You can name a guardian for your minor child. The next seminar we're going to do, we're going to talk about this specifically and why it's so important to do that. All right, so tune in for the next seminar. Let's talk about how to avoid probate, because probate in my world is a 4-letter word. Yeah, it's got more than 4 letters, but it's a 4-letter word with some explicatives at the end. So, and I say that because it's a lawsuit against your estate. It takes a long time to carry through the court system, which means anywhere from 3 months to sometimes a year and a half, 2 months, depending on the complexity of the issues. It's expensive. Remember, I charge generally around the $5,000 mark, and that can include costs. It could be 5,000 plus costs. Just depends on, again, the assets, how many beneficiaries you have, how many creditors you have. So the cost can really vary. Sometimes you're not even going to know. A lot of attorneys won't give you a flat fee. They'll give you an hourly rate, which you won't know how much it costs by the time this is done. I charge everything on a flat fee. So all the estate planning I do is a flat fee. You know exactly how much it's going to be when you agree to work with me or when I agree to work with you. So it's important to set a time to talk to me about what you have and how we can avoid probate, and if any of these options are best for you, okay? So Gray's put a little link in the chat box for you to click if you want to set a time for me. Let's jump right into ways to avoid probate. So we can gift it before death, we can name joint tenants, life estate, irrevocable trust, and a revocable trust. Now, what are the differences? So if we gift it before death, and I'm using a house here as an example just because it's easy to see. You can think of these as bank accounts, as stock brokerage accounts, pretty much anything that you can put a title on, all right? Or put in your hand, it's something that's tangible, so a tangible asset. A house is usually the easiest example. So you can immediately gift it. So you can gift it before death, okay? Couple caveats here. So if you gift it before death, and for some reason, and this one's not even on here, some reason you've got to have long-term medical care that you would qualify for Medicaid for, and you gift an asset before death, Medicaid can actually do a 5-year look back and say, hey, you gave this money, this $100,000 to your son. We're going after your son now for that $100,000, or you're going to have to pay out of pocket for as long as it takes to get to that $100,000 of care, okay? So these are all expenses that are not taken care of by most insurances, not taken care of by Medicare, but it's specifically Medicaid and long-term care where you require assisted living, okay? So it's another area of law. If you know anybody in that situation, we can certainly help them out with that as well. All right, we work with other attorneys that specialize in that specific area. So the other part of gifting it before death is it's immediate. So yes, you're giving that gift right away. Can be a plus, it can be a minus. Just depends on what you really need to do. You lose control of that asset because you've gifted it to that person. That person now has total control of it, even if you had a side arrangement where that person was not supposed to spend the money, wasn't supposed to do anything with it. You lose control, you lose ownership. And then you've got creditor risks. Not your creditor risks, but the creditor risk of the person that you're giving it to. Let's say you want to give your house to your son, right? And if it's the house you're living in, now you're losing your homestead right to that. It's not a homestead anymore, so it's not creditor protected because you've given it to your son who doesn't live there, so you lost that homestead protection. And your son, maybe he's got creditor issues. Maybe he's got credit cards that you didn't know about. Maybe he's got IRS debt that you didn't know about. Now those creditors can come and take that asset or force a sale or foreclosure or put a lien on that asset. If it's a bank account, they can just come and take it. They've got to have the right orders and everything in place to do that, but they can do it. So it's important that you understand the creditor risk of what you've got going on and the person that you're going to give the asset to. Okay, if you've got a mortgage, that could cause a whole nother issue if you transfer an asset, transfer a house to someone, because that mortgage could be called due right away. It's due on transfer. And also a gift tax issue. We're not going to go into that in detail here, but there could be a gift tax issue. All right. So that's gifting. I do not recommend gifting for all of these reasons and many, many more. Another way to avoid probate is to title your accounts as joint tenants or as just co-signers on an account. Anything that you would think of where you have two people together on an account, when one of them dies, the other one receives the asset, okay? Or in the, excuse me, in the sense of a house, as long as it's properly named as joint tenants, then it'll pass to the person that survives, all right? Again, this is an immediate transfer. You'll lose control because now you don't own it alone. You now have joint ownership. Think of a bank account. A bank account, there's $100,000 in a bank account and you're on it and you just decide that, well, I want this person to have it when I die. Well, now this person can take that money anytime they want. Not just half, they can actually take the whole bank account and not really get in trouble because they are joint owners of that account. Same thing with the creditor risk. All right, the creditors can say, hey, you're on a joint account. We can take that money. There are, of course, exceptions to this rule, like for married people, for just depending on what's going on with that. But generally, we're not talking about marriage here. The mortgage, again, could cause an issue with due on transfer, no step up in basis because you're a joint owner. So you take that as if your mother bought a house and bought it for $100,000 and added you to the title as a joint tenant with rights survivor, and 10 years later dies, that house is now worth $500,000. You don't get that step up in basis like you would in several other planning strategies. Okay, you get it at $100,000. So that means if you sell it, you now have to pay taxes from that $100,000 to that $500,000 because those are capital gains. All right, so that's a tax issue, and there could be a gift tax issue as well. So not the best solution. Once again, not the best solution. Then we have a life estate. This is what I often refer to as the cheap estate plan. Once again, not the best way to do it. It does work. And I suppose if you really don't have any money, this could be the best way to transfer an asset, a house anyway. It's like we talked about with the husband and the wife and the older children. So she would get a life estate, and you can name yourself as having a life estate, and then deed the rest of the ownership to whoever you want it to go to. It doesn't have to be your children, it can be anybody. And that's called the remainder interest. Right? So you keep a life estate, you deed the remainder interest, it transfers on your death, the owner's death. You could lose control depending on how that deed is written. You do lose partial ownership of that. And there could be a creditor risk to the person that you're naming as a remainderment because it's probably not the house that they live in. If it is, fantastic. But it becomes an asset that goes to them immediately upon your death. And if they've got existing creditors, those creditors can come in and attach a lien or sell it or foreclose on it, depending on the situation, of course. Mortgage does transfer with the property, so you've got to make sure there are other assets that are taking care of the mortgage if the person that you're giving the property to doesn't have the means to pay for the mortgage. Okay. The remainder has no rights to the property at the time. So that can be good or bad depending on what your wishes really were. That means they can't kick you out of the house until you die, of course. So there's that one protection there. Again, not the best way to plan, okay? Then we move on to irrevocable trust. Now, a lot of people think of a trust and they usually think of irrevocable trust. Because when I speak with people and I educate them on the types of estate plans, they usually mention, well, I don't want to lose control of my assets. And generally that's with an irrevocable trust, meaning you cannot change it. There has to be a court order usually to change an irrevocable trust. You have to have cooperation of everyone involved, and the court generally has to say, yes, you can change this. Okay, that's the only time you might end up in a probate court is because of an issue with the trust, right? So with an irrevocable trust, again, it's immediate. You give up control, you have limited ownership, your creditor risks are controlled, so that's good, and even your creditor risks are controlled. So if you've got creditor issues that come up after you've transferred it into the irrevocable trust, your asset is now protected. The reason I wanted to emphasize that after your irrevocable trust is set up is because if you've got creditor issues before you set up an irrevocable trust and you move your assets into that irrevocable trust, there could be an issue with what we call a fraudulent transfer. That means you knew you had a creditor issue, you knew you had a creditor that was out there that was trying to collect on a debt, whether it's a lawsuit or credit card charges or a lien of some sort, and you move your assets into an irrevocable trust or even transfer them to somebody else, like we mentioned earlier, that can be considered a fraudulent transfer. Meaning they can now go after the person that you transferred it to, they can have everything reversed, they can do a whole lot of things to correct that issue, that fraudulent transfer. So be very, very careful with that. So you can also name a trustee. So you can name somebody that will take care of that asset that you hope will follow your instructions on how you want it handled, but they don't have to. They follow the instructions of the trust, and they protect you and your assets. So if they see that you've got a creditor out there, they can do a lot of things to protect the asset from your creditors. All right, you do get the step up in basis, and we still may have a mortgage issue, most likely not, but it is possible with an irrevocable trust because you are no longer the one in charge or in control of that asset. All right, so not the best solution for most of the people out there. But most of the people that I work with will fall into the next category. Irrevocable trusts are also really good for estate taxes. All right, our estate taxes are almost $12 million per person right now, which means if you do not have more than 12, it's like 11.8 something million. If you don't have more than that, you will not have an estate tax issue. Florida does not have an estate tax issue. Other states do. So if you've got less than 12 million, you don't have an issue. If you've got more than 12 million and are single, you have an issue. So if you've got, say, 22 million, 10 million of that will be taxed at an estate tax issue, right? Estate tax rate of right around 40%. So that out of that 10 million, 4 million is going to the federal government. So that is one of the reasons people set up irrevocable trusts if you're in that high of a tax bracket. If you're below 12 million, 24 million as a married couple, a regular revocable trust will suit your needs right now. If the tax laws change, that's when you look at everything and make the changes necessary. I generally would go with a little bit different tax planning at the $5-6 million mark. So you want to take a look at that. Always let your attorney know exactly what your assets are so that you can be protected. All right, our final way to avoid probate that we're going to talk about today is setting up a revocable trust, okay? Slight difference, irrevocable and revocable. Revocable trust, you may have heard of living trust, you may have heard of living revocable trust, revocable living trust. They're all basically the same, right? They transfer the asset immediately into a trust. You, as the owner of the asset, transfer that asset into the trust and maintain total control. You still maintain total ownership through the trust. You are still the beneficiary of that trust while you're alive. So you're the person that put the asset into the trust, you're the person that manages the trust, and you're the person that gets the benefit of the asset inside the trust. Whether it's a house, a bank account, your business, you have total ownership. Creditor risks are controlled for your beneficiaries, meaning when you die and your named beneficiaries are alive and well and they're ready to receive that money will stay in the trust until the person that you name as the successor trustee, that's the person that takes over managing the assets inside of that trust, take over and, like I said, they take over and manage the assets for your beneficiaries. If they see that their beneficiary has a creditor issue, they can hold back giving them the lump sum of money or the asset, because that creditor, once again, can come in and say, hey, that's mine, I get it. So the successor trustee can make that judgment call and keep that asset inside the trust, which gives that beneficiary creditor protection on that asset. So instead of just handing over the whole asset to the beneficiary, the trustee can just pay for whatever the beneficiary needs. They need to go to college, they can write a check to the college, not to the beneficiary. They need to go to the doctor, a check to the doctor. If they need to buy a car, they write a check to buy the car. This keeps that money safe, similar to an irrevocable trust, because a revocable trust becomes irrevocable when the trustor or the person that started the trust dies. Okay, so we've got that creditor protection for your beneficiaries. Okay, you also get the step up in basis, like we talked about before, where you didn't get it naming somebody as a joint tenant, meaning that if you buy that house at $100,000, it's worth $500,000. They go to sell it at $500,000. There's no capital gains tax on it because they get it in that stepped up basis, and that can save you much, much more money than creating a plan that does not do what you wanted it to do. So much more in tax money, so much more in probate fees, or just trying to figure out what's going on. Mortgage. Most mortgages actually have a little couple line sentence that says that if you're transferring this asset, this home into a revocable trust, that is, you are the trustor, you're the trustee and the beneficiary, it's not going to cause a due on transfer clause to kick in. So you're fine with the mortgage. The mortgage just kind of goes along with it. All right. So those are the 5 ways to avoid probate. Has anyone seen all of those, some of those, none of those? You can put in the chat what you've seen, what you haven't seen. And then we're going to open it up to some Q&A as well. So please type in your questions, and I'll be more than happy to answer them. And while you're doing that, I'll finish off with the only guarantees in life are taxes and death. So the more we prepare for both, the less expensive it will be for you and those you leave behind. So make a plan for your family's well-being. And I know a lot of people that don't pay taxes, but when they die and they don't plan properly, they'll get those taxes maybe on a step-up in basis for sure. Do we have any questions? Once again, our legal disclaimer. A way to set up an appointment, a free consultation with me. And Gray has put the link in the chat box, so go ahead and click on that and schedule a time with me. We'll chat about exactly what type of situation you have and what it should take to avoid probate for you. And if you've got questions about your children and don't want to wait until the next seminar, feel free to set a time and we'll chat about what happens with your children or how you can plan for your children. All right, I've got one question. If you have a parent that is easily talked into anything, is an irrevocable will better? All right, so there's not an irrevocable will. There is an irrevocable trust. All right, so the difference again is will has to go through probate. Trust does not. I don't even know of an irrevocable will, but an irrevocable trust, it could be better if the family is all together and you all agree about what should happen. And remember, it's the parent that gets to make the decision. Okay, if they're easily talked into, which is manipulated, or a couple other nasty words that could be used under duress, stress, and they're creating a plan that they perhaps don't want, then yeah, maybe an irrevocable trust is the way to go. As long as you've got a whole family meeting and everybody that's involved is there, that might be a good way to go. But you also want to look at the mental capacity of that parent. Does that parent actually have the mental capacity to enter into a contract, enter into a will or a trust? So a lot going on there. So don't take that as specific advice, but as a general sense of what you should get checked out. Okay, no questions, but thank you for the information. All right. Yep, you can also call Gray and she can set up a time to meet with me. So thanks for pointing that out. Thank you for the information. Approximately how much does it cost to write up a will? All right, great question. So it varies. So it's going to depend on your needs. And I generally say between $2,000 and $5,000, we create an entire plan for your family, for you and your family. What that includes is, we'll go with the will plan. The will plan is with a will. You also receive a power of attorney, a medical surrogate, which is like a medical power of attorney, somebody to help make medical decisions for you, a living will, which is the document you would need if you're on life support and you do not want to be left on life support. If you've got children, we can add the children's documents, so naming a guardian for the children. So that's at the $2,000 level. Step up to the $3,000 level, and that's where we add a trust. Okay, and remember that trust avoids probate, and the cost of probate is more than covers, the cost of preparing the estate plan more than covers the cost of doing probate, which eliminates the cost of doing probate. So will plan, we still have to do probate. Trust plan, we don't have to do probate, so we have that cost saving in actually doing the probate and the length of time that it takes to do the probate. And everybody is mourning your death and now has to go through this horrible court process. Okay, so definitely worth the money to get the trust plan if you've got assets that would have to go through probate. And we can discuss that during the consultation, what assets actually would have to go through probate.
Marty, I wanted to just touch on an important subject, which I think is what we're going to really talk about in the next webinar. But I just wanted to bring up how important it is to have something in place if you do have young children, because it's not only if you pass away, but if God forbid you were in a car accident or if you have fallen ill and you don't have something in place as to who's going to take care of your kids, can they end up in the foster care system or taken by the courts until this is all sorted out, or how does that work?
They absolutely can. And that's really the main focus of my practice, is to avoid any child being put in the custody of the state. It's children first. Children are our most valuable assets. We've got to make sure they're taken care of, and never in the custody of the state. Yeah, and if you don't properly plan, you don't have somebody on standby waiting to receive the most horrible call to go pick your kid up at school, then yes, the state can come pick them up and wait till the courts settle who gets the kids. So definitely important, and we'll spend the whole time on that in the next webinar. So watch for that.
Thank you very much.
I don't see any other questions coming up. And did I answer, Anna, did I answer your question? So it depends on what you need, but if you give a general number between 2,000 and 5,000, most of them come in at the 2,000 or 3,000 mark, depending on the assets. If you have a significant amount of assets and want us to help you transfer the assets into the trust, then that's where you're at the $5,000 range.
I also wanted to ask Michael, he's on the line. I know that he currently got his will done with you, and he couldn't speak enough good things about you and how easy the process was and how you had all the documents ready and how everything was seamless, and he really appreciated everything you did for him, Marty. I just wanted to bring that up and let everybody know that, you know, you shouldn't be intimidated to get this process started. This is something that's very important, and that with Marty's help, it would be something very easy to do with his guidance.
Yeah, thank you. Thanks, Michael. I appreciate the nice words. I got those. So yeah, I've made the process as easy as possible. I've got everything streamlined where we spend a minimal amount of time on the phone, if that's what you want. If you want to spend longer on the phone, that's what you'll get. If you want a Zoom call, we'll do that. If you want to meet at a restaurant, we can do that. We're not meeting people in our office at this time, but I certainly can meet you somewhere if you're a face-to-face kind of person. Most people have gone on to Zoom or just a phone call. So as much or as little time as you need to make sure we have a plan that's right for you. And then the rest of the process is pretty seamless, where I've got a easy to follow online form that explains every bit of what information I would need to put together your plan for you, so you'll have the proper plan in place. Okay, I've got videos for you to review the documents with, and I'll review them with you if necessary as well. Just try to make it as easy for you as possible. And then we meet to sign the documents. So we have witnesses, and I am also a notary, so I can either do a mobile notary or we can meet at my office and sign that way. So really flexible on how you need your documents drafted, how quickly you need them drafted, and when and where you need them signed. So I'm more than happy to help with all of you on that.
You also handle power of attorneys, correct? For
right.
elderly parents and.
Yep. Power of attorney, guardian for the parents, medical surrogate for the parent, for the children. So we've got all of that covered. We make sure your kid is covered from now till they're much, much older. So that's why it is always planning for your family's well-being.
Thank you, Marty. Thank you so much for this wonderful information.
You're welcome. All right, well, I think that's it. So thank you all very much. I look forward to speaking with you, and talk to you soon.
Bye, everyone. Thank you so much for joining us. If you have any questions, please feel free to contact me. My email is gdiaz@whistlerlawfirm.com, And the phone number is 561-708-0513. I can assist you with setting up an appointment with Marty or pass along any questions that you may have. Thank you so much for joining and look forward to speaking with you soon.
And my info is there too. So take a screenshot or picture of the screen, and we're all set. Thank you all.
Bye-bye now.
Bye.